Hi, everyone. Welcome to the webinar. I'm going to give everyone a minute to get in from the waiting room. And I will crank up the closed captions. That'll take a minute also. Okay, welcome everybody. Thank you for joining us today. I'm so glad to have Anna Bernal Roberts here with us to bring awareness to Domestic Violence Awareness Month, which is October every year. Anna is a staff attorney at the Legal Aid Society of the Orange County Bar Association. So I'd like to thank her for taking time out of her busy schedule to do this webinar for us. And I'd also like to thank the Public Interest Law section of the Florida Bar for co-sponsoring this webinar. We did submit CLE credits, but they are still pending. So as soon as I get those, I'll send them out to everybody. The closed captions should be live now. You'll see a red live box at the top of your screen, and you can just click on that link, and I'll also put it in the chat box as soon as Anna gets started. Let's see, and I'm Christy Baglow, the Director of Statewide Training at Florida Legal Services. This will be recorded and all the attendees will get a recording, and I'll also post it on our YouTube page, which Zoom will take you to the YouTube page after the webinar. So Anna will be taking questions after each section of her presentation, so feel free to type questions in the Q&A box, and I'll be monitoring the Q&A and the chat boxes as we go. So I will hand it over to Anna now. Thank you for joining us, Anna.
Thank you. Thank you, Christy. Hello, everybody. I'm going to be discussing VAWA and U visas. So after I'm done with VAWAs, I will take some questions and then I'll move on to U's. Okay, so VAWA was first enacted in 1994 by Congress, and it was created to provide immigrant victims of domestic violence with legal remedy to obtain legal immigration status independently of their abusers. So there it is, the section where you can find it. Despite the name being women, men, and children also qualify. VAWA applicants are not subject to the law, to the new public charge rule of inadmissibility. So some of the benefits of VAWA, it allows victims of domestic violence to self-petition and obtain legal permanent residence without having to rely on the abusive spouse or parent to start a complete the process. Once the VAWA petition is approved, relatives of United States citizens may obtain legal permanent residence immediately. Relatives of legal permanent residents must wait for a visa to become available. They're able to remain in the US under deferred action and legally work. Once applicants become legal permanent residents, they may apply for citizenship. And then the time to apply, if they got their legal residence through marriage, they have to wait 3 years. Otherwise, they must wait 5 years. So I just want to mention that being a US citizen is completely different from being a legal permanent resident. So a lot of people get confused. They think it's the same thing, but it's not. You have to be a legal permanent resident first before you can go ahead and apply for citizenship. Really, the only advantages to becoming a citizen are that you're able to vote, you're able to travel more freely, you don't have restrictions on travel, and you can't get deported if you commit certain crimes. So that's really the only difference. So a lot of people never really apply for citizenship, but that is a benefit that you can get after a certain amount of years in that status of residence. Okay, so who's eligible under VAWA? So an abused spouse of a US citizen or legal permanent resident, an abused child of a US citizen or legal permanent resident, a non-abused spouse of a US citizen or legal permanent resident whose child is abused by the US citizen or LPR spouse, an abused parent of a U.S. citizen son or daughter. So look for the abused parent. It has the abuser has to be a U.S. citizen. In that category, it cannot be a legal permanent resident. Son or daughter must be 21 years old or older. So overview of the self-petitioning requirements. An LPR or U.S. citizen spouse abused the self-petitioner or his or her child during the marriage. If the self-petitioner is a child or parent, the abuse could have happened at any time. It doesn't have, obviously, because they're not married, so the abuse could have happened at any time. But if it's through a spouse, it must have happened during the marriage. The self-petitioner was subjected to battery or extreme cruelty by the U.S. citizen or legal permanent resident spouse, and the self-petitioner lived with the abuser at some point. The self-petitioner must currently be living in the U.S. Exception: victim may still qualify if the abusing spouse is an employee of the U.S. government or armed services. If the self-petitioner is an abused spouse, the self-petitioner must have married in good faith. The self-petitioner has good moral character, and the abuser must be a U.S. citizen or legal permanent resident. So when I say self-petitioner, that's our client, that's our victim, okay? USCIS must consider any credible evidence filed by the self-petitioner to meet the eligibility criteria. The regulations suggest there are some documents that should be submitted. However, the self-petition may not be denied for lack of a specific document. USCIS cannot make an adverse determination using information furnished solely by the abusive spouse or family member. Requirements. There must be a qualifying relationship to the U.S. citizen or legal permanent residence. There must be a good faith marriage to the U.S. citizen or legal permanent residence. There must be battery or extreme cruelty. Joint residence with the abusive spouse or with the abusive LPR or U.S. citizen. Good moral character. So these are the requirements to be able to qualify for VAWA. So requirements for a qualifying relationship: spouses and children of U.S. citizens or legal permanent residents, a parent of a U.S. citizen, but not the parent for an LPR. Relatives of parents do not qualify for derivative status. Self-petitioner may still qualify if legal permanent residence lost his status due to an incident of domestic violence. Self-petitioner must file within 2 years. So in cases where the abusive spouse lost his residence due to the abuse, our client would still have 2 years to file. The self-petitioner will not be affected if the abuser loses his status for any other reason after the petition is filed. If the self-petitioner divorces the abuser, which happens a lot, the abuser may still qualify as long as she files within 2 years of the divorce. So when you're meeting with clients and they need immigration status and they're married to an abusive spouse and they're going through a divorce, you need to make sure that they are aware that they only have 2 years from the divorce to file under VAWA. There must be a connection between the divorce and the domestic violence. Divorce for any reason after filing the VAWA will not affect that petition. The spouse of a deceased U.S. citizen who died within 2 years preceding the filing of the self-petition. This provision does not apply to spouses of abusive legal permanent residents, children of abusive U.S. citizens or LPRs, or the parents of abusive U.S. citizens. So it only applies for the spouse. Children of the U.S. citizens who did not file before turning 21 may file prior to turning 25 if the abuse was one central reason for the delay in filing the self-petition. The abuse may have occurred before the abuser became a U.S. citizen or legal permanent resident. Bigamy. If the self-petitioner remarries after the approval of the self-petition, the self-petition will not be revoked. With bigamy, what I did want to say, I don't think we explained it right here, but with bigamy, I did have a case where we found that our client had married someone who was already married. So she didn't have a valid marriage, but she did not know that. But we were able to prove that she, in fact, believed she was married because they went through a ceremony. She, you know, we have pictures of the wedding. I mean, she had a wedding dress, everything, but he had tricked her into believing that it was a real marriage. And in fact, it wasn't. So in that case, we actually won and were able to get that VAWA approved. Okay. Requirements, qualifying relationship. Evidence to show qualifying relationship to U.S. citizen or legal permanent resident. So you will need a marriage certificate or birth certificate, proof that the abuser is a U.S. citizen or LPR. That can be proven with a copy of his U.S. passport, copy of his green card, or his birth certificate showing that he was born in the U.S. Proof of prior divorces of the abuser and of self-petitioner to show that you have a valid marriage. If you cannot obtain documentation of abuser status as an LPR or U.S. citizen, under 8 CFR section 204.1, USCIS will attempt to verify through their databases, but it's not guaranteed, and so they may still deny the case. So you'll have to demonstrate your efforts to verify the status, and you have to include as much information as possible about your abuser, like his date of birth, place of birth, social security, school records, etc. And then self-petitioners create affidavits of the abuse and of the marriage. So you have to explain that in your affidavit as to why you couldn't come up with that proof of his status. Requirements for good faith marriage. So you have to show that marriage was not entered into solely for an immigration benefit. Must show that the self-petitioner intended to establish a life together at the time of the marriage. And self-petition cannot be denied because parties no longer live together and the marriage is not viable at the time of filing the self-petition. So some of the evidence to show good faith marriage is the self-petitioner's affidavit from family and friends, birth certificate of children born to the marriage, deeds of property or leases showing both spouses' names, joint bank accounts, joint tax returns, joint credit cards. All of these are listed right here. Anything you can think of that would show a marriage was in good faith. There's really not magic documents that you must submit, but the more the better. So what are the requirements for battery or extreme cruelty? The self-petitioner must show that she or her child has been battered or has been subject to extreme cruelty by the spouse. Definition by the spouse or parent. Definition includes physical, sexual, and psychological acts, as well as economical coercion. This may include threats to beat or terrorize her, hitting, punching, slapping, kicking, or hurting in any way, emotional abuse, such as insulting in private or public, sexual abuse or exploitation, threats to take children away, hurt children or pets, threats to call immigration, controlling where she goes, what she does, who she sees, forcibly detaining her, threats of or committing an act of violence against the third person or thing in order to scare or pacify her. For extreme cruelty, you must show engaging in a pattern of acts that alone would not constitute abuse, social isolation and degrading the victim, accusations of infidelity, incessantly calling, writing, or contacting her, interrogating friends and family, threats, economic abuse. Here's the wheel for physical violence that I'm sure that many of you have already seen in the past. power and control you. Requirements for joint residence. So the self-petitioner must have resided with the abuser. The statute does not specify the amount of time they must have resided together. But if you get somebody that's only lived together for a month and the abuse was horrible, they're going to understand that you're not going to stay in a marriage for very long. In other cases, when the abuse is just emotional and maybe there's not enough evidence, those cases are very hard to prove because the marriage, the length is so short. So those are hard. The self-petitioner must be residing in the US, or the self-petitioner, if living outside the US, can self-petition if the abusive spouse is an employee of the US government and the abusive spouse subjected the self-petitioner or the self-petitioner's child to battery or extreme cruelty in the US. So these are some of the requirements and the evidence you can show to show joint residence. An affidavit of the self-petitioner, letters addressed to the abuser and the self-petitioner together or separate at the same address, bills in both names, rental lease with both parties or property deed, employment records, school or medical records, joint accounts, utility bills, phone bills. It's really important to tell victims before they start trying to start this process to make sure that they gather all documents. If they're moving out of the residence, to make sure they gather as much of documents as possible, because they don't realize how much that will help them through this process. Sometimes they don't have anything. So requirements for good moral character. The self-petitioner must show good moral character. It must be shown for 3 years preceding the filing, but immigration can still examine prior history beyond the 3 years. These are some of the bars to good moral character. I'm not going to read them all, but they're here. I don't really have many of these bars with my clients, but these are the ones listed, and you can find them at INA section 101F. Requirements for good moral character continued. Oh yeah, there's a special exception to the statutory bar to good moral character found at INA 204. The self-petitioner must show the act or conviction is waivable and the act or conviction was connected to the abuse suffered by the self-petitioner. So some of the evidence to show good moral character, you would need to get a police clearance letter from all jurisdictions with the self-petitioner has resided for 6 months or more during the 3 years before filing the petition. You will need an affidavit from the self-petitioner stating that they are of good moral character. If good moral character is at issue, supporting affidavits from friends, family, employer, pastor, etc. Okay, so now we're moving on to VAWA derivatives. Who can be a derivative under VAWA? Derivative children may be included in the self-petition. Must be unmarried and under 21 years of age. Must prove relationship. So you need to have like a birth certificate. Do not have to reside in the US. So your children can be living in their home country and you can still include them. May obtain the same benefits as the self-petitioner. So deferred action is just status that's given at the beginning and that allows them to get a work authorization and then they're eligible to adjust eventually. They do not age out after turning 21 as long as the petition has already been filed. And once they turn 21, they're classified under a different category and retain original priority date. So for self-petitioning, what the process entails, you would need a cover letter. You will need an index with all the documentation that you're submitting, a G-28, which is the notice of appearance as the attorney. The I-360 is the VAWA petition. and evidence that meets all the eligibility requirements. You will need to file this with the Vermont Service Center, and there's no fee for the I-360. Immediate relatives of U.S. citizens, which are spouses, unmarried children under 21, and parents, may file the I-485 and I-765 at the same time. So if you are an immediate relative, together with the VAWA self-petition, you can also file for your residence with the I-485 and for your work permit with an I-765. But those do have a fee that you must pay, or you must request a fee waiver by filing another form called the I-912. And not everybody qualifies for a fee waiver, but a lot of our clients do, since we're in a nonprofit. Okay, relatives of LPRs and non-immediate relatives must wait for a visa to become available. Most follow, this is where you can find the visa bulletin letting you know the time frames for the wait. You must check the priority date, category, and country of origin to determine if I-485 may be filed, because you have to wait a certain time if you're not an immediate relative to file an I-485 after the VAWA petition has been filed or approved. The VAWA has to have been approved, I'm sorry. Must extend deferred action until priority date becomes current. And that means the deferred action will allow you to work until the priority date becomes current, and then you can apply for your residence. So you must complete, in most of my cases, they qualify to file concurrently because their abusers are usually US citizens. Then we file the I-360 together with the I-485. All documents previously listed are at I-360 approval. If you're filing after the I-360 was approved, you would have to show, obviously, file the I-360 approval. You can still file for the waiver. I'm sorry, the G325 is no longer needed. I don't know why it's still showing up on there. I forgot to edit that out. So the G325 is no longer needed. The I-131 is an application to travel, and I-864W is an affidavit of support exemption. So you need to send medicals. And copy of your passport and I-94 if applicable, copy of birth certificate of a translation, evidence of a relationship for derivatives. So these are all the documentations needed. There are special requirements for self-petition adjustment. The self-petitioner does not need to be inspected or admitted. So if they entered undocumented, that crime is forgiven under VAWA. And let's say family-based petitions where they've entered undocumented, the spouse can file for them, but if they've entered undocumented, they actually have to file a waiver to get that forgiven. And eventually they must return to their home country and come in again through the embassy. So it's kind of a little bit scary to have to do that. But with VAWA, that's forgiven. That's a huge benefit, because if you have a client that just crossed the border, that illegal entry will be forgiven. And that's not forgiven with a family-based petition, let's say. So if that relationship would have lasted and the spouse filed for them and there was no abuse, that would have been something that they would have had to overcome.
Anna, a real quick clarification question. What is a derivative?
Oh, a derivative is somebody that you can include in your petition. For example, a lot of my clients are the wives. And so the derivative would be a child that she had that also needs immigration status. So a lot of my clients already have kids that are also undocumented, and now they married a US citizen. So when they file for VAWA, they can include their child as a derivative.
Okay, thank you.
You're welcome. The self-petitioner will not be disqualified if she worked without authorization. A lot of my clients have worked without authorization, and they always think that this is going to be a problem, but you just have to explain it that they work without authorization. And as long as they haven't committed fraud, like they haven't been using somebody else's identity, A lot of my clients even have tax ID numbers and they can work without authorization. And under VAWA, as long as we are truthful and explain why they work without authorization and what they did, a lot of times they clean houses, etc. That's never been a reason for a denial. If they've overstayed or violated terms of non-immigrant status, that just means, like, let's say they enter with a visitor's visa and now they've overstayed, meaning they didn't leave. That's not going to be a reason for denial either. If they've been admitted as a crewman or alien in transit or admitted under a visa waiver, none of these would be reasons to be disqualified. I don't know if that'll make sense to everybody, but for adjustment for the I-485 process, the self-petitioner must be admissible under INA section 212. So the self-petitioner falls under one of the inadmissibility grounds. There must be a waiver available. Okay, so after you file for the VAWA, you would get a receipt notice, then you would get a prima facie determination, which is issued by immigration. If the self-petitioner submits an I-360 and evidence supporting all of the elements required for a self-petition, that's what you get. You get a prima facie determination. It doesn't mean that it's approved. It just means that on its face, it looks like it would be approved, but it does not mean that it's approved. This notice allows self-petitioners to obtain some public benefits as qualified aliens. USCIS will send a request for evidence if additional evidence is needed to establish the requirement. You usually have 12 weeks to respond to a request for further evidence, and there's no extensions. Except during COVID, there were given some extensions. The regs require USCIS to submit a notice of intent to deny and the opportunity for submitting additional evidence before denying the self-petition. If denied, you may file a motion to reopen or reconsider with Vermont Service Center with Form I-290B within 30 days of denial. Okay, so that was VAWAs. I think that it may make more sense if there are questions and answers, because I know a lot of this may not make sense if you haven't handled it. Are there any questions for VAWAs before I move on to U visas?
Yes, we had quite a few questions come in, and boy, am I glad we have you and other advocates to help clients. I really can't imagine someone trying to go through this on their own. A lot of
documents.
A lot of forms and a lot of little ins and outs.
Yeah.
I'm amazed. So let me see. The first question was, does the abuse need to take place in the US?
Yes.
Okay.
Unless you were married to the US Armed Force, like somebody in the Army, and you are overseas through that work, then it could take place over there. But that's really the only exception.
Okay. And you already answered the derivative question. So the next question is, in what ways can we prove battery or domestic violence if the client did not report due to fear or there are no records because the police did not create a report? Can videos and text messages be used to show abuse and control?
Yes, videos and text messages can be used to show. I actually submitted a bunch of texts in one of my recent cases where there was a lot of threats, et cetera, et cetera. So where there's no police report, that's not required, but that's very helpful. But what I do is a lot of my clients have filed for domestic violence injunctions. So even if it was denied, you can at least show an attempt to get an injunction. Sometimes they've gotten mental or like counseling sessions. They've gone through Harbor House counseling sessions, and there's evaluations done. I forget the name of this agency that really helped in one of my cases where there was not much evidence, but I wish I remembered the name of it. But she had gone through many counseling sessions, and there were very detailed reports as to how she was feeling. And like, I was able to get all those records, and it showed that she felt worthless, and she talked about the abuse, and they diagnosed her with depression. So I used that, and I think that's what won that case for me. So if you have a case where there's not much evidence, get your client in contact with someone that can provide some therapy sessions, and that way there's records of this person trying to obtain this to overcome the abuse. If they've done, if there's any letters of people that know about the abuse, there can be some corroboration through that. Or an affidavit that's very powerful. Sometimes if there's no abuse, some affidavits are like enough to win the whole case. Like if you can really explain all the abuse you've suffered, and your affidavit and all the feelings you were going through and how it's affected you. Some clients are better than others at explaining this. Some of them are going to need a lot of help creating these affidavits, but that's one of the most important pieces of evidence that you can have. And explain why you didn't report it. Like, why were you afraid, and why don't you have more evidence of this? So like I said, there's not a requirement that you must have a certain document. Like nothing is requiring you to ever reported this to the police, and you can explain why you didn't report it. You were afraid to, and why.
Okay, so the next question is for the waiver of EWI under VAWA. Do I need to file a separate form, or is it automatically waived?
It's automatically waived.
And remind me again what EWI stands for.
Entered without inspection.
Okay, I knew it was something about crossing the border, but I can remember.
Yeah.
Okay, and on the same line as that, same question for the waiver of the work without authorization. Is it a separate form?
Nope.
Okay.
You just have to, when you're completing Form I-485 or I-360, they'll ask you, have you ever worked without authorization? And you must say yes. And then if you've answered yes, at the end of that form, you would have to explain. And then you would say, I worked without authorization cleaning houses. I did it to provide for myself and my minor children. I didn't use anybody else's ID. I got paid cash, or I have a tax ID or whatever. As long as you didn't commit fraud, like you're not using somebody else's identity, it hasn't ever been an issue.
Okay. Can a self-petitioner ask for a waiver of 212A9C reentry after an order of deportation?
I am not sure about that.
Okay.
I can try and find that out, but I'm not sure about that.
And how have you submitted videos to USCIS and transcripts and screenshots?
Well, I've never submitted a video myself, but I know that you can. But what I have submitted are texts, and my clients are the ones who get them all printed out for me. And so when my clients print out those texts, I don't know, they have a whole packet of texts, and then I go through them and I submit them like that. I've never submitted a video, but I'm assuming you could just submit one of those little chips that you can plug into the computer. But yeah, you can submit a video if you want to. I've never done that, but you can.
All right, I think we have one more question. It's about deferred action. Can you only request an extension for deferred action through submitting the I-765? That is the language in the deferred action notice. The issue is that
you can just send a letter as well. And sometimes it's automatically given, honestly. They've automatically extended deferred action, but other than that, you can just keep applying for the I-765 every time right before it expires. And that's usually enough.
Okay, there's a lot more abbreviations and numbers coming here, so I'm going to do my best here. The issue is that the clients have EAD, I think that's early action deferral.
EAD is an employment authorization document.
Okay, through pending AOS, which means...
Through a pending adjustment of status.
Okay. We'll translate as we go along. But also they received the EAD as C31 approved VAWA. Moving forward, what is the best option? EAD through C9, C31, C14, deferred action.
Okay. Are they able to hear my answers, or are you having to respond to them?
Yes. Yeah, everyone can hear the answers, and I just read out the questions so everyone kind of knows what we're...
So basically what happens is when you file for VAWA, I don't know, can you ask that person asking the question if their client is married to a US citizen?
Okay. All right, typing that in case they're joining.
Yeah, so I'm going to respond in both scenarios in case I don't get it. But basically, when you file for VAWA, and you are able to file for both the VAWA, and then the adjustment of status. So the VAWA is the I-360, the adjustment of status is the I-485, and then you also apply for the employment authorization through the I-765. While that case is pending, sometimes the VAWA gets approved, okay? So at some point, the VAWA will get approved first. At that point, immigration will send you an employment authorization based on C-31, and that's C-31 means deferred action. And that means that based on VAWA approval, you qualify to work. At the same time though, which happens a lot in my cases, my client also has an employment authorization through C9, because when you apply for I-485 adjustment of status, you can also apply for employment authorization under C9, which gets you working right away. As soon as you apply for VAWA, you can apply for the employment authorization under C9, because you don't want to wait for your VAWA to get approved to get that deferred action. But like during the processing of the case, if the VAWA is approved, they also send you a work permit under C-31. And now at this point, sometimes clients have 2 work permits. So moving forward, sometimes it's the C-31 helps, because sometimes the employment authorization under C-9 expires, but then the VAWA's gotten approved. So now you have a longer time to wait before you need to renew, because you're able to work with a C-31. But moving forward, if you need to continue to renew your work permit, you have to do it under C-9, because that C-31 is only given to you once. And if you have an adjustment of status pending, then do it under C9 to renew it. The only reason you would do it under C31 is if you don't have an adjustment of status pending. Okay. So yeah, to do it under C9 moving forward, if that's what you have also on the plate.
And the client is married to a U.S. citizen.
Yeah, I assumed it, because otherwise there probably wouldn't be an AOS also being processed.
Okay, and in the chat, some people were giving suggestions about the videos and texts. Mm-hmm. So let me just see if, oh goodness, there's a lot of ideas in there. So I'll try to figure out how to send everyone the chat. Okay. Let's see, because they had some creative ideas and some pros and cons. I think we did have one more question. Let me check real quick.
The only thing I can say about tags, make sure you read all the tags before you send them, because some stuff may be incriminating to your client. Some of it may look bad for your client. So make sure you read every single text before you're going to send text. Don't just send a whole thing of text that your client gives you without reading them.
Right, that makes a lot of sense. Okay, so we had another question. What can you tell us about spouses who are actually being wrongfully accused of abuse as an attempt by the undocumented spouse to get a VAWA claim? What sort of things can the non-abusive spouse do to protect themselves?
Well, I mean, we've had cases come through where I didn't really feel like the client was being truthful. And in those cases, we just don't take that case. We only want to take those cases that I feel are, real abuse, especially because we're a nonprofit, right? So we're not trying to get money out of anybody. We're taking those cases that are the most deserving. And those cases where I feel like, the client has met through the internet, they've only known each other for 2 months, and then they got married. The client is 30 years old and the spouse is 60, and they've only been together for 2 months, and now she's saying she's being abused. That's a lot of red flags for me, and that may be a case where that's that avenue is being abused. So in those cases, I don't ever do anything to obviously we can't, it's confidential and we're representing my clients. So in those cases, we usually don't take, and we send them somewhere else and we tell them why their case does not seem strong. Now, to answer the question about what we can do to help the non-abusive spouse, that is not going to be a criminal record for the abusive spouse that's being incriminated, right? So that person, just because somebody files a VAWA, and even if it gets approved, it's not going to show up on that person's record as a crime. Okay. Even with injunctions for domestic violence, those are civil in nature. And I know that even though they're civil in nature, depending on the spouse's profession, if they're a cop or something, that may really affect their profession. But other than that, even injunctions are civil in nature. And with immigration, nothing happens. Nothing happens to that abusive spouse if he was wrongfully accused of this. you know, she may be able to get the paperwork approved if she was able to do a really good job at making it seem like she was a victim, but nothing's going to happen to that spouse criminally or show up on his record or anything like that.
Okay, that's good to know. All right, I think that's it for questions. A few people had some more detailed questions, so I'll email them separately and see if you're able to do those offline.
All right. So should I move on to U visas now? I'm going to move on to U visas, okay?
Sounds good, thank you.
All right. Okay, the U visa is a non-immigrant visa developed to aid victims of certain crimes in obtaining lawful status in exchange for their cooperation with law enforcement in prosecuting the perpetrator of the crime. It was created by the Victims of Trafficking and Violence Prevention Act in October 2000. The standard of proof to establish eligibility for the U visa is any credible evidence. And a recent rule requires that all fields on the U visa form, which is the I-918, be filled. And please believe me, it's true. It is true. They will deny it if not all fields are checked. So it's a pain in the butt. You have to complete each field. Each field, do not leave anything blank. U visa applicants are not subject to the new public charge rule of inadmissibility. So here are the statutes and regulations that you can find this law. The eligibility. So the client must have suffered substantial physical or mental abuse resulting from criminal activity, possesses information concerning the criminal activity, has been, is likely to be helpful in the investigation or prosecution of the criminal activity. Certification has been obtained from a federal, state, or local law enforcement authority, and the criminal activity violated the laws of the U.S. or occurred in the U.S. If victim is under 16, incompetent or incapacitated, then a parent or guardian may possess the information or be the helpful party. So what are the benefits of the U? It allows non-citizens to stay in the U.S. legally for up to 4 years, allows for work authorization, and allows for derivative visas for immediate family members. So we know what derivative means now, right? So I think that question was already asked. Allows for adjustment of status to lawful permanent resident. There's limitations of the use. Only 10,000 U visas are able to be approved each year in the entire country. If the 10,000 runs out, subsequent U visas will be pushed to the next year. The 10,000 number does not apply to derivatives. So they're only counting the principal applicants. Before I move on, so when I first started doing U visas, the processing time was maybe about a year and a half. And now it's like 5 and 5.5 years because so many U visas are filed each year and only 10,000 can get approved. So the wait is very, very long. Substantial factors, suffer substantial physical or mental abuse. Okay, so substantial factors, the nature, so you have to look at the nature of the injury, the severity of the perpetrator's conduct, the severity of the harm suffered, duration of the infliction of harm, permanent or serious harm to appearance, health, physical or mental soundness, physical or mental abuse. If you're trying to prove that, the abuse does not have to be physical. Any mental abuse may suffice, but the mental abuse, impairment of emotional or psychological soundness. Those are going to be harder to prove, though. Just keep that in mind. If it's mental, you're going to have to prove that it rises to the level of extreme cruelty. The victim can be a direct or indirect victim. Direct victims are those who have suffered direct harm. Indirect victims can be family members of the victim of murder, manslaughter, or one who became or who becomes incapacitated as a result of the crime. So here's a list of all the crimes that qualify for you. I want to give you a second to go through those. I don't want to read them all, so just read through them. Okay. So the qualifying crime does not have to be a felony. So what does has been, is been, or is likely to be helpful in the investigation of the crime mean? This requirement is established by Form I-918 Supplement B Law Enforcement Certification. The criminal investigation does not have to lead to an actual prosecution of the case. You can obtain, hold on. Oops, so sorry. I think I went. Okay. And you can obtain a U visa even if the crime occurred years ago, as long as law enforcement will issue the certification. So basically, if you have been a victim of one of those qualifying crimes, as long as you can get a certification from law enforcement, and that could be the police, that could be the state attorney's office, as long as you can get a certification from law enforcement, that allows you to go ahead and file for a U visa. But they're not required to certify. And you must show that you cooperated with any requests for assistance and that you reported that crime. You must obtain I-918 Supplement B certification from law enforcement. This is mandatory. Without it, we cannot even file for U visa. Can be a police officer, prosecutor, victim advocate within the prosecutor's office, and even a judge. Tips for obtaining. These are, you must educate law enforcement through memos, establish a relationship with the authorizing party, find out what the local policies and use them to your advantage, work with domestic violence advocates, law enforcement signs at their discretion. Law enforcement is not required to sign, and the certification is not a conclusive evidence. So just because you get the certification does not mean that your case is going to get approved. It just pretty much gives you the ability to file with immigration, because the sole purpose of U visas are to help law enforcement investigate and prosecute crimes. The criminal activity violated the laws of the U.S. or occurred in the U.S. includes Indian country, military installations, and territories and possessions. So these are the forms in the process that are required for U visas. So you must file the I-918, which is the petition for the U non-immigrant status. You must file that together with the signed I-918 Supplement B, which is the law enforcement certification. And additional documentation would be trial transcripts of the crime. If the crime was, I have a lot of cases that are at the state attorney level for criminal cases. And so if you have the transcripts of that trial, the depositions, the police reports, affidavits, photographs, medical records, etc., your petitioner's written statement. If it's because of abuse, then you have to have, you don't have to have, but what is helpful is medical records, mental health evaluations, witness statements, photographs, etc. And Form I-192 waiver of inadmissibility is something that you must file if it's required, depending on your case. So for U visas, if you've entered undocumented, it's not like VAWAs where it's like immediately forgiven. For U visas, if you've entered undocumented, you must file Form I-192. Okay, so that's one of the difference with U visas. You must have a birth certificate, valid passport. If you have a passport, you must include that. Not everybody has a passport though, especially if they've entered undocumented. The passport style photos. And all of this is also sent to the Vermont Service Center. So it's the same place where you file VAWAs, that's where you file it. There's no fee for the I-918. However, there is a $930 fee for the I-192, which is that waiver of inadmissibility. A fee waiver can be requested if the person qualifies financially. So after 3 years in continuous U visa status, the U non-immigrant can apply to adjust status to a lawful permanent resident. So basically, if a U visa is approved after 5.5 years, if you're lucky enough and your U visa is approved after waiting for 5.5 years, you're giving U visa for 4 years. You're eligible to apply for your legal permanent residence after having U visa for 3 years. And the reason you have it for 4 is so that after 3 years you apply, then you have that 1 year that you still have some status with U visa, okay? So make sure you apply right after the 3-year mark for the legal permanent residence status. If you forget and it's been past the 4 years and your visa has expired, you are no longer able to apply for your legal permanent residence. So when those cases are approved, you usually close out the case, because I don't keep track of when those 4 years will, and I'll let the clients know in the letter. I meet with them, and they have to make sure that they understand that this is only valid for 4, and that they must return within 3 years, or after 3 years, to our office if they want our assistance to do the adjustment process. There's no numerical cap for the number of U adjustments. So the cap is only for the actual U visa, okay, the 10,000. Requirements: was granted and continues to hold U visa status, has continuous physical presence for 3 years in U status, is not inadmissible under INA section 212, and that refers to Nazi, genocide, torture, or extrajudicial killing. Those are the only crimes that are not forgiven under U visa. So as long as your client hasn't done one of those, you should be good, as long as you file for a waiver. And your waiver must include all crimes. So I mentioned earlier that you have to file that waiver if you entered undocumented, but in that waiver, you can list any other crimes that your client has committed. You must list all of them so that you're forgiven for all of those. So if you don't put one in there, they can deny you later because you did not ask for that crime. You did not report, reveal that crime in your waiver. Has not unreasonably refused to aid law enforcement, and presence in the U.S. is justified on humanitarian grounds to ensure family unity or is in the public interest. A U visa petitioner must be admissible. However, most grounds of inadmissibility may be waived. Any ground of inadmissibility may be waived in the public or national interest except, and I think I already went through those earlier, those are the ones that are not waived. Derivatives include spouses, children, parents, and siblings. A derivative cannot be the perpetrator of the crime that led to the U visa in the first place. So if your spouse is the one who abused you and that's why you're basing your U visa on, you can't include him as a derivative. A derivative U visa holder can adjust just like the principal can. So these are some of the qualifying family members. So this is a little tricky. So you kind of have to sit down with a client and figure out who would qualify as a derivative. So if your principal, if the principal is under 21 years of age at the time the petition is filed, the qualifying family members include the principal's spouse, unmarried children under 21, unmarried siblings under 18, and parents. If the principal is 21 years of age or older, only the spouse and unmarried children under 21 are eligible for derivative status as qualifying family members. The qualifying relationship must exist at the time the petition is filed, continue to exist at the time the petition is adjudicated, and continue to exist at the time of the derivative's admission to the U.S. The age of the qualifying family member is established on the date on which the principal filed for the U non-immigrant status. An unmarried qualifying family member, known as child under 21 years of age, who has a derivative petition filed by the principal, will continue to be considered a child throughout the entire adjudication process, even if the qualifying family member turns 21 years of age while the petition is pending. If the U principal petitioner is under 21 years of age when the petition is filed, unmarried siblings under 18 of age at that time, and parents will still be considered qualifying family members, even if at the time of the adjudication, the principal is over 21 years of age, and even if the unmarried sibling is over 18 years of age. The age out protections do not apply to a change in a child's or sibling's marital status. So do not get married. Your derivatives cannot get married. So that doesn't, so if that changes, then you don't qualify, then that derivative will not qualify. The relationship between the principal petitioner and his or her spouse must exist at the time the principal petition is filed, and the relationship must continue to exist at the time of the spouse's subsequent admission to the U.S. Okay, so This is the contact information that VAWA and U-Visa attorneys can contact Vermont Service Center. There's a hotline. You can leave a message at this number. Only attorneys of clients that have cases pending there can call that number. They will not return that your call if you don't have a G28 with them. The G28 is your notice of appearance, and they must have a case pending, and that's the only time they'll return that call. So if you're not an attorney with a case pending through Vermont, you can't call them. And I think that's it. Any questions on U-Visas?
All right, thank you so much for all that information. We had a couple leftover questions from VAWA.
Okay.
Just to clarify, if a self-petitioner uses a fake social security number or someone else's social security number, would they not be eligible to apply?
I still have applied, and I still have gotten those cases approved. They haven't questioned it, honestly. I have never had a request for evidence to explain that. I don't know what would happen if they did send a request to explain, I usually try not to mention that. So when they ask, there's not a question on there that says, have you ever used somebody's social security number, right? There's not a question. So you don't volunteer that information. They've asked you, have you ever illegally worked? You respond, yes, I worked illegally, but you don't go and explain what you've done. So they've never asked me about that. So I don't know what would happen if they did ask that question. We would have to respond, but as of now, I've never had that be a problem. And some of my clients have, not many, I think maybe 2 that I can recall. And we filed and we responded, yes, we worked without authorization. But they've never questioned that part of it so far. I don't know, they could get tougher.
Well, that's good to know. Also on the VAWA subject, can you just clarify that there's no minimum length of marriage? Like, for instance, if the person comes over on a fiance visa and there's absolutely no abuse until they're actually married, and then they get out soon after, is that okay?
Yes. So the client comes in with a fiancé visa. They must marry within 3 months of entry. They get married, and now there's been abuse over the last 2 months, and now they've only been living together. The abuse has happened during the marriage. It must happen during the marriage. That's the key. The abuse must happen during the marriage. And it's only been 2 months. Yes, she can still file. There's not a requirement of any lengthened time. Now, in those cases, if the abuse is not something that can be proven with a lot of evidence, if the abuse was not very severe, those are going to be harder cases to prove, because they're going to question your intent to come in. They're going to look at like your age. They're going to look at the spouse's age. They're going to look at like how long you dated before you got your fiancé visa. They're going to look at all of that. So when the marriage is short, they're going to look at everything more cautiously. But yes, you can file, and you may have a great case depending on the abuse.
Okay. And there's a U-Visa question. When a U-Visa derivative is outside the US, what is the process?
Okay. So you basically would have to file for the U-Visa, and you would include the derivative in your U-Visa application with an I-918A. So you have to file an I-918A for the derivative. And if everything gets approved and the I-918 gets approved, then you have to go through the National Visa Center to get them in without approval. You have to actually have a different case after everything's approved to now get them in through the embassy in that country, in whatever country they're in. But you must file the I-918A if you have a derivative that's also going to be applying for the U visa. So you have to wait until the entire case gets approved, and then you have to go through the National Visa Center with that approval to bring them in.
Okay. And someone in the chat box commented that the state attorney's office can be difficult to work with when there's a pending case due to discovery and Brady issues.
Yes.
Has that been your experience also?
That is my experience. Yes, they will not sign a certification until that case is closed. So especially now with COVID, so many trials have been postponed. They will not sign it unless the case is already closed. So sometimes you're waiting a while, and that's not a requirement under the U visa. Like nowhere does it say under any of the regulations that a case must have been closed, but it does say that law enforcement has complete discretion as to when and if they would ever sign. So that's our state attorney's office in Orange County has that rule where they will not sign a certification, a 9918B until that case is closed. In those cases, you may try to file to get the certification through the police department if there was an arrest file, a police report filed. So if you don't want to wait at the state attorney's office, go ahead and file with the police department. But I have less luck with the police department than with the state attorney's office. A lot of times the police doesn't even respond. And if they do, a lot of times they won't approve it. At least with the state attorney's office, it may take longer because the criminal case has to be closed. But I have success with them actually getting the certifications. Most of mine are approved for that certification, but I do have to wait a while.
Okay, and speaking of police, I've heard in some special counties, like where I live, the sheriff's office has decided that they don't believe in U visas, so they won't. Is that a thing? I mean, I'm hoping that's not true.
I don't know what they mean by they don't believe in U visas. Are they saying that it's fraudulent, or are they just not?
They just won't assist with an affidavit or coming out or anything.
Yeah, well, they won't assist you with an affidavit. The only thing that they will do is sign that certification. And if they don't want to sign it, they don't even have to give you a reason why they're not signing it. They don't have to explain themselves. They have complete discretion as to whether they want to sign or not. And you can't force them. The only thing to do is educate that police department and maybe go in and see if they can, you can present to them as to what a U visa is and what it really means, because they may not understand it fully as to why they're signing this, right?
Okay.
But they do have complete discretion if they want to sign or not.
Okay, that makes sense. I think that's it for questions. Let me just check real quick and make sure I didn't miss any. And I'll save the PowerPoint and the chat discussion in a shared folder and send it out to everyone with the recording, because this was so much information. I'm sure everyone needs to look at it again.
Maybe I should have just done under VAWA first, right? Maybe I should have just done just VAWA and then.
Thank you so much, Anna, for all this information. It was amazing. And I am just even more amazed by everyone who does this work every day. So thank you to all of you who are supporting domestic violence survivors through your jobs every day. I know that is a really tough job, and I appreciate all the hard work and heartache that goes into representing these survivors. So thank you everyone for the work you do every day. And thank you, Anna, so much for this training. And I will send out the recording and all the other materials tomorrow.
Thank you, Christy. Thank you, everybody.
Take care, everybody. Bye.